discussion on the Affordable Care Act case because that's coming up tomorrow. And then we had the election, and then we know that we're going to have a lot of court filings that go along with the election. So I took a revisit through Bush v. Gore, for those of us who remember it, and the Hanging Chads. And for some of us who don't, for some people who don't, I thought it might be a little helpful to have a revisit for that for students, because I'm sure they're going to have a lot of questions on how many times can a president appeal, and what are the processes, and what is the actual route to it. So today we are going to have we're going to fully walk through the Supreme Court, what it is, what it does, how the makeup is, how cases get assigned, how a case actually gets there. It's not that a case can just simply say, I'm going to go to the Supreme Court. How many cases apply versus how many cases are selected, and really why cases are selected, and how they, kind of get assigned to the judge who does the assigning, who does really kind of the lion's share of the work. And then we're going to talk a little bit about the federal courts and what the federal appellate courts do, and then really what their role is. And we're also going to take a brief look at what have sort of been the 10 defining Supreme Court cases since the Supreme Court was founded, and why they've been the 10 defining cases, for better or worse. So thank you very much for joining me. And I'm going to share my screen so we can pull up my PowerPoint presentation, because they are the bane and joy of everybody's existence. So here we go. So again, today's objectives, we'll cover the Supreme Court, what the Supreme Court does, how a case gets there, the assignment process, the kinds of cases that it hears, and the argument process. You'll also learn the role of those who come before the court, and why a Solicitor General always has an advantage. We'll then examine the Federal Appellate Court, their number and structure, the role of money in the Supreme Court system. And then we're going to cover the Federal Appellate Court, their number and structure, the role of money in the court system, and how that influences the cases that make it to the Supreme Court. This is really suited for grades 6 through 12. And then we're going to have a small kind of breakout workshop to apply what we've gone over, and that you can also use with students. How would you apply the law and why? So with that, we will progress to the Supreme Court. And one of the cool things that when you go into the Supreme Court is it says equal justice under the law, right when you go in. It's very impressive. So there are 9 justices. As we all know by this point, I'm sure. The appointment to the Supreme Court of the United States is for a lifetime or until they choose to retire. Some justices do choose to retire. There is a Chief Justice, and the Chief Justice assigns case. He is the person who actually assigns cases to a justice who will be responsible for writing the opinion. The Chief Justice also is responsible for any tiebreakers that come up. So what kind of cases come before the Supreme Court? They are limited by the Constitution to hear cases and controversies. Oh my gosh, that's so specific. Isn't that helpful language? The Pillar case was really Marbury v. Madison. It was an 1803 case. And it stated it is emphatically the province of the judicial system, of the judicial department, to say what the law is. And this is where we started to see really the shaping of the Supreme Court as the body that defines the law for the United States of America, using the Constitution and the Federalist Papers as their interpreting documents. Their jurisdiction comes from Article 3, Section 2 of the Constitution, and also from the U.S. Code 28, Section 1251. So they hear appeals. They will also hear appeals from the federal courts, from the U.S. Court of Appeals in the Armed Forces, and appeals from state court as a last resort of federal constitutional or statutory law. We'll be revisiting that later. So those are the types of cases that they hear. So how do you get there? You think that you've been wronged in a federal court. You file your what is called a petition for a writ of certiorari. So if you're a litigant and you wish to file an appeal brief, then you go ahead and you write that out and you ask to be heard. It must be formatted perfectly or it will be rejected. I know this from personal experience. It has to be in 10 font. And then you send that off. And if the Supreme Court, who receives 10,000 of these a year, and all of the clerks who work there, the thankless, brilliant lot that they are, because getting a Supreme Court law clerk assignment is one of the holy grails of law school. So they do nothing but read these certs as they come in, and they try to choose which certs look interesting. So if one looks interesting, one of two things happen with your cert. It either looks interesting and they send it back to you and they say this cert has been approved, and then they send down for the record, or they just send it back and they say cert denied. You usually stomp about your office and say that's a total miscarriage of justice. How can they not see why this is important? They have this wrong. This is completely outrageous. And then you live to fight another day. However, if they do decide to hear it, what they do is they send down to the lower court for every single piece of paper that has ever been filed in this case. They also notify the other side. Now, at this point, the responses that are possible are the other side can acquiesce and agree that the court should hear the case. They can waive its right, which never happens. They can file an opposition brief and say, I don't think that the case should be heard by the Supreme Court. And what is more and more common is you see an amicus brief gets filed. An amicus brief is what is called a friend of the court brief. And these are things that will be filed by, say, the ACLU, the NRA, so sort of depending on what your issue is, you will have, your issue may have a lot of friends. There are think tanks in and around K Street that do nothing more than monitor what gets picked up, and they decide whether or not they want to be your friend. And then you'll see all these amicus brief gets filed, but by the National Labor Relations Board. It truly gets to be a little impressive. So what happens next? Well, at that point, most of the work is really done by the clerks. The cases that are selected usually have a constitutional impact. They are not looking for a case that has some small contract law issue. tried a patent in federal court, and because it was a slightly overlapping issue and you weren't happy with the outcome, they don't really care about that. They're looking for cases that really have some constitutional issue or in some way impact a large group of people. So not every case, there's this common belief that every single case that comes down from the Supreme Court is some huge barn burning decision. They're not. A lot of them are really relatively boring. But when you read a little bit deeper, you'll see why they chose it. It was established in 1789 by the Judiciary Act. Congress sets the number of justices. It has been at 9 since the mid-1800s. We are going to skip FDR's court packing thing. The court sits in session from October to July. It also hears emergency orders from the Federal Appeals Court, and it works on a 2-week on, 2-week off schedule. Now, it does this because if it did nothing but hear cases from all of October to all of July, when is it going to write its opinions or have time to discuss cases? There would be no time to discuss anything. So they're very orderly about this. So that's why they have that 2 on, 2 off schedule. And in those 2 weeks that they're off, they are discussing the cases that they have just heard. They are figuring out kind of where they're going to come along in them, what their opinions are going to be, what their thoughts are, where the law is going to be on it. And so they're really actively discussing these opinions during that time and actively discussing the arguments that they've heard. And the clerks play a huge role also during this period because they do a lot of the research to support it, to support those decisions. And again, the Chief Justice is always the person who assigns cases. He's very fair with assigning the cases. And if they are in a 4-4 position, then he will be the person who casts the tie-breaking vote. Each side only gets 30 minutes to argue their case. So each case only gets 30 minutes to argue their case, and they have little timed lights. It goes green, then yellow, then red. So imagine, if you will, that you have spent your whole life waiting to get to the Supreme Court. And this is the case of your life. This is going to make you or break you. And you have 30 minutes to make your argument. And then after you make your argument, you get questioned by some of the best legal minds that we have in the country. I will not editorialize. But one of my favorite things to do is listen to the Supreme Court argument days and listen to, Justice Kagan and Justice Roberts and Justice Sotomayor and even Justice Scalia, who I didn't always agree with, but he always had these blistering questions for people. So each side gets only 30 minutes. No television cameras have ever been allowed in the Supreme Court. No television cameras ever will be allowed in the Supreme Court. And the United States is represented by the Solicitor General. And that person is underneath the division of the Department of Justice. Now, I had said earlier that when you're the Solicitor General, you have an advantage. And part of why you have the advantage is because if you are somebody who only goes before the Supreme Court, let's even say you're the ACLU and you're there a lot. The Solicitor General appears there all the time because they represent the United States of America, right? And most of the cases involve the United States of America. So being the Solicitor General, they get to know what the judges are like, what they're going to ask, the kinds of questions they're going to ask. And they get a sense of the rhythm of the court. They know the clerks, they know what, they kind of know what to expect. So there's a common saying that if you're a Solicitor General and you're representing the United States and you lose a Supreme Court case, it's a little bit unthinkable, because that should always be a little bit of a layup for you. So and then the plus, you have the, and I've said this all the time, you have the limitless resources of the United States of America. I said this all the time when I taught at Northeastern. When somebody has been charged in a crime by the United States of America, imagine any one of you who have been charged with anything, and you've been charged by the United States of America, and now you have to fight that. You have to go out and you have to hire a defense, you've got to hire experts, you've got to do all those things. Well, your budget is this, and the United States of America is unlimited. So it's never really quite a balanced fight to begin with. So the briefs who join are called the amicus briefs, or the friends of the court. And the more controversial the case, the more friends you will have. And this is because the briefs often cost upwards of 6 figures to research. Going to the Supreme Court is not a cheap thing to do. You're looking at a small fortune in research, in site checking, in writing, in printing costs, in mailing and delivering things to opposing counsel. So it can easily run into 6 figures. So you have these well-funded political interest groups who pick these things up and go, oh, I want to be a friend of that issue. I want to be a friend of this issue. I want to be a friend of that issue. And they all sort of hop on as amici briefs. And they literally do nothing but specialize in Supreme Court appellate law. This is what they live. This is what they breathe. Bless their hearts. Example, tomorrow the ACA will be heard. The Solicitor General is going to represent the United States in California v. Texas, and this is yet another Affordable Care Act case. In tomorrow's Affordable Care Act case, the argument is whether states and private individuals have suffered an injury sufficient to create a something to challenge the constitutionality of the individual mandate. It will consider whether the individuals have been injured because they only purchased insurance because they felt compelled to through the ACA, and whether the states have been injured because the individual mandate costs more to buy insurance and increases the state's administrative costs with tracking and maintaining ACA compliance as employers of these individuals. If the court finds that standing exists, it will decide whether Congress is setting the penalty that was rendered on the individual mandate as an unconstitutional command to purchase insurance. as the lower courts held, or whether Americans can choose whether to purchase insurance or not with no penalty for the latter. ACA stands if SCOTUS adopts the second view. If the ACA agrees with the lower courts that the individual mandate is unconstitutional, it must decide whether the individual mandate is severable from the rest of it. So they would have to pick and tease out portions of how the ACA would stand and then how the ACA would go on. So the decision would be an extremely complicated one. I will be listening to the argument tomorrow. The Supreme Court justices. So we have Chief Justice John Roberts, who was put in by Bush 43. We have Justice Clarence Thomas, who is just super conservative. We have Justice Stephen Breyer, who is a Clinton appointee. We have Justice Alito, who was put in by Bush 43. We have Justice Sotomayor, who was an Obama appointee. Justice Kagan, who was an Obama appointee. Worth noting, she was also a Solicitor General for the Bush 43 administration. Justice Gorsuch, who was put in by Trump, and Justice Kavanaugh, who was put in by Trump. And then we have our final edition justice, her name escapes me, who was just put in by Trump. And I'd like to talk for a moment about justices and how their politics tend to change. There's this sort of commonly held belief that you can predict what a justice is going to do based on the president that appoints him or her. Chief Justice Roberts has been a fine example. Justice Roberts was a Republican appointee, and yet many of his decisions have been, I wouldn't say liberal, but many of his decisions have been in line with the law. You know, he doesn't just swing wildly left because that's what he's expected to do. And this was particularly noted on the Affordable Care Act, when he decided in favor of the Affordable Care Act, and also when he's decided in favor of other cases that were considered to be very liberal cases. Another justice I always think of when we think about justices and their politics and is that going to define them, is Justice Hugo Black. And he was appointed in the mid to late 40s. Justice Hugo Black was a card-carrying member of the KKK. And was appointed to the Supreme Court. And he went on to become one of the most liberal justices in the history of the court. He was crucial in the Brown v. Board of Education decision. He was crucial in a number of the decisions that we will go through later. So sometimes I think it's important to look at who somebody is when they come into the court, and that they're on for a long period of time. And justices, like all people, change over time. Okay, so Bush v. Gore. How many people remember Bush v. Gore? Anybody? So Bush v. Gore, so it's Bush v. Gore was in 2000. It was an Equal Protection Rights Clause decision. George W. Bush applied to the Supreme Court for cert after Al Gore asked for a Florida recount. He had won the popular vote, but the electoral votes in Florida held the balance of the election. And when you added those Florida votes in, the election went to Bush 43. So Gore used a Florida statute that allowed him to ask for a recount, for a manual recount. And they began that recount and, the hanging chads and the whole 9 yards. Then he went to the Florida Supreme Court, and he was denied on the reasonable standard theory. And what he was told was that a plaintiff must prove reasonable probability that the election would have turned out differently. And from that, let me just go back up here. And from that, the case went up to the Supreme Court. And in the Supreme Court, where Bush applied for cert and was granted cert, what they said was, look, we're not going to get involved because it's not up to us to decide what a state does. And we agree that Florida made a hot mess of their voting process. But we don't see any real proof that any wrongdoing was done. Every county had a different procedure. We agree that was wrong. But without evidence of any wrongdoing, there's not enough reason for us to justify a full recount. So they denied it because it was going to go past December 15th. And they said, look, that's Florida knew on November 9th that they were asked to do a recount. They haven't taken any steps to start a manual recount. We cannot hold an election up past December 15th. And the balance of those electoral votes went to Bush 43. It left a very, very bad taste in everybody's mouth. And it also led to a series of events that delayed, kind of Bush 43 being in office in a timely fashion, having a transition team, the same way it would Gore, by the way, if Al Gore had won. And it set off a trend of the Electoral College deciding the vote when the popular vote had been decided the other way. So I expect that's going to come up yet again, because there have already been something like 7 or 8 lawsuits filed, which is why it's always important when you rent someplace that you look at the date that you have to be out by. And in this particular case, you have to be out by January 20th. You don't get to stay there past then. You do have to, it is a firm date. You have to be out of the White House by January 20th. I think it's in the lease signature. So I think it'll be a little interesting to see what ends up happening with this and all of the things that I'm hearing and watching getting filed, because I haven't seen any evidence. Now, this is not 2000, this is 2020. The ballots, as I have seen, were all counted underneath cameras and scrutiny and with people standing over them. And So again, I think it's going to be very interesting to see what sort of happens with this. So one of the things I had talked about was the influence of dissenting opinions, or actually I haven't talked about it yet, but the other side of the law and the influence of dissenting opinions. So as you read down, and some of you may have already done this with your classes. So when you read Plessy v. Ferguson, which is a horrible decision, you see a tiny little ray of light in one of the dissents. Those dissents are what lay the groundwork for what comes later on. Sometimes they can lay the groundwork for what comes later on in a very bad way. So when we look at the Griswold decision, which was a decision involving marital couples' right to use contraception, that decision was based on a right to privacy. Well, that decision kind of laid the groundwork for Roe v. Wade, which was also a right to privacy decision. Now, sometimes it can kind of work in the reverse, and you'll see how one little snippet of a bad dissent can send a message out to people who want the decision overturned. I have never seen anybody give a better explanation of this than Senator Sheldon Whitehouse did during the Judge Barrett hearings. And I don't know how many of you have seen this, but I think it is always worth a re-examination. So we are just going to take a look at Senator Whitehouse's walking us through the Janus saga.
So it gets a little weird sometimes, and that's a circumstance I'd like to bring up to you because it touches on some of the stuff that I addressed yesterday. One case, it's not even a case. You know Janus.
Yes.
Okay, let's describe this as the Janus saga because it's more than really one case. And it's really about a completely different case called Abood. You're familiar with the Abood decision?
Yes.
So the Abood decision was precedent for what, 40 years?
I can't remember when Abood was decided, but it was precedent before Janus.
Yeah, and roughly 40 years, I'll tell you. And had repeatedly been reaffirmed.
It was a longstanding precedent.
Yeah, on which there was considerable reliance.
Let's see. So Janus did overrule that precedent, and so Janus did go through the application of the stare decisis factors in deciding whether to overrule it,
Right.
whether that
And there was in fact reliance in the 40 years that it had been the law of the land on the question of the union question that it had resolved.
Well, I don't want to second guess or criticize or praise the majority in Janus's
I'm not asking you to. I'm
calculation.
asking you, as a matter of fact, had 20 plus states relied on it?
Well, Senator, I think reliance and the degree of reliance on Abood is a legal question.
We'll just leave that then. So the Janus saga begins actually with a case called Knox, in which Justice Alito took a shot at Abood. He criticized it as substantially impinging upon First Amendment rights of union members. Just for people who are watching, the Abood case was about the right of a labor union to get compensated, not dues, but just compensation from non-members when in their representation of their members, they get added benefits for the people who are not members. So not the most exciting part of the law, but settled this question of when labor unions could get compensated for work they do for non-members. But Justice Alito did not like it. He took a shot at it in Knox versus SEIU, and the concurrence in that case said, whoa, wait a minute. Quote, the majority's choice to reach an issue not presented by the parties, briefed or argued, disregards our rules. But Justice Alito didn't like something about Abood, and so he took that shot. Then we went on to a later decision called Harris v. Quinn. Alito took another shot at Abood in that case, describing Abood as having analysis that is questionable. He undertook an extended critique of the decision, describing it as having questionable foundations. Justice Kagan spotted that, and in her dissent, she said, today's majority cannot resist taking potshots at Abood, and described its critique of Abood's foundations as gratuitous dicta. But the message went out from Judge Alito that he wanted to do something about Abood. There was something about Abood that he did not like. And with that, we went to, that's the prequel. Then we went to the two cases that followed. The first one was Friedrichs, which was supposed to be the case that got rid of Abood. And it had an interesting travel because the lawyer in the case was one of these groups from Janus. It was the Center for Individual Rights right here, who was counsel. In Janus, the National Right to Work Legal Defense Foundation was counsel. So they switched, right? In Friedrichs, Center for Individual Rights was counsel, National Right to Work was an amicus. When it went on to Janus, they switched. National Right to Work Legal Foundation, Defense Foundation was counsel, and Center for Individual Rights was an amicus. And from everything that I see, it looks like they actually went out and found the plaintiff. So back to our earlier discussion, it wasn't the injured person that went and hired a lawyer. It was the legal group that went and found a plaintiff. And then they went to court, which everybody does, but it got interesting there because there the lawyers asked to lose. I don't know if you've ever been in a case in which the lawyers asked to lose before. I never have been. I've never litigated against anybody who asked to lose. Have you ever been in a case in which a party asked to lose?
No, I don't think I've ever experienced that.
Yeah, I can imagine not. So these groups with all this money behind them from Donors Trust and Bradley Foundation and all come into court and they say, please dismiss my case in the district court. Then they go up to the Ninth Circuit and they specifically ask the Ninth Circuit to get rid of their case, to uphold the decision dismissing their case, quote, as quickly as practicable and without argument. Have you ever seen a case in your circuit where somebody came in and said, I'd like to lose, and I'd like to lose as quickly as practicable, and I'd like to lose without making an argument on behalf of my client?
But Abood was controlling law at that point, right?
My question was, have you ever seen that happen in your circuit?
I have not seen that happen in my circuit.
Yeah. Okay. So then the case went on to decision, and as predicted or signaled by Justice Alito, it looked like it was going to be a 5-4 decision knocking out Abood after 40 years. Sadly and unfortunately, Justice Scalia died before that decision could be rendered, so it actually turned out to be a 4-4 decision. And as you know, a 4-4 decision, the tie goes to the decision below, and the Ninth Circuit prevailed, and so that was it for Friedrichs. But it didn't take long for this same group. So this is back to my Janus exhibit. These are all the commonly funded amici and lawyers who showed up in Janus. 11 of them had showed up in Friedrichs. So Janus was a reunion of the team, everybody piling back in together to get what they, and there was no big rush this time, because this time they had to wait for the vacancy on the court to be filled. They didn't want a 4-4 decision, they had to wait for Justice Gorsuch. So there wasn't the same rush. The case came through more ordinary travel, and then, boom, in they went to argue it, and down came the decision. And I ask you to think that through, because I've done some appellate argument, and I've done some trial work, and I have run an awful lot of litigation. And one of the things that has been a constant for me has been the belief that even if I was kind of taking a long shot case, I'd get a fair hearing, I'd get a fair decision, and I had a shot. I've got a feeling that the lawyers going into the United States Supreme Court in that Janus case, looking at this array of commonly funded anti-union front groups assembled against them as amici, having seen what Friedrichs portended, having been signaled by Alito in those earlier cases that they wanted to get rid of Abood, that they was on the hunt for Abood. That's a feeling that no lawyer should have in America. And all I want to do is leave with you the thought that when you're on the court, I hope you will conduct yourself and see in whatever way you can that the court conducts itself in such a way that no lawyer goes into an argument in the United States Supreme Court feeling that the case is set against them and there's nothing to be done other than go in and take your medicine.
Hey, Lisa, I think it's pretty clear that money is a big factor. Who's got the funding?
Yes, and that's one of the things behind the amicus briefs. And I know that somebody had said that's not how they, that's not how they teach the Supreme Court. And this would be something more for a high school level. But when you look at all those amicus briefs that get filed on and sort of piled on, there is a huge amount of money. And what ended up happening in Janus is the unions lost their rights for a bargaining representative, and it was ruled unconstitutional. So more and more you see special interest groups, and I only use Senator Whitehouse's explanation because it's one of the best explanations of what has really become of the court system since Citizens United. There has become this sort of privatization that we have never seen before. So these sort of top Supreme Court cases, everybody's list is different. These are the ones that I always put in the top. Whenever you're looking for a case to choose with students to study. Marbury v. Madison, 1803. A law repugnant to the Constitution is void because everything starts with Marbury v. Madison. Dred Scott v. Sanford, 1857. Slaves are the property of their masters. I believe the exact phrasing used was chattel. This is the decision we can never forget, because this is the darkest point to me for the Supreme Court. Followed by Plessy v. Ferguson in 1896 that said that Jim Crow laws were perfectly constitutional and that separate and equal was fine when it came to education. And then we have this big gap when we go down to Brown v. Board of Education. Separate but equal has no place when it comes to education. And the great Thurgood Marshall. Mapp v. Ohio. And you'll start to notice a trend here. Mapp v. Ohio, 1962. Evidence illegally obtained cannot be used in the trial of that matter. This was when we started to see the poison fruit defense. Miranda v. Arizona, which came out of Terry v. Ohio. You have the right to remain silent. Roe v. Wade, which came out of Griswold. Abortion was based on a right to privacy. One's right to abortion was based on a right to privacy. Bush v. Gore in 2000, the recount The recount cannot be conducted in compliance and due process without substantial additional work. Citizens United versus FEC, the Federal Accounting Commission, in 2010. And although it was innocent in what it was thinking, when it said that because corporations are people underneath the law, and for some reason I have lost my little Zoom thingy here. There we go. We'll come back. What's going on here? So, Citizens United, the First Amendment applies to all individuals in the United States. And because corporations are indeed individuals, then they do also have First Amendment rights. You cannot say that a First Amendment right applies to Lisa McGonagle, but it does not apply to General Electric, because General Electric is considered an individual underneath the Corporation Act. I don't think that anyone had the idea it was going to turn into what it has turned into, but be that as it may. And then there is the District of Columbia v. Heller, which, if this thing would just go away. The District of Columbia v. Heller was a 2008 case. It was a Second Amendment case, and I think it is one of the best reads for any classroom. I say that because it is a brilliantly written opinion. Scalia did an amazing job with this opinion. It revolved around the Second Amendment rights. A special police officer who lived in Washington, D.C., who wanted to have a handgun in his home. At the time, the Washington, D.C. laws said that you couldn't have a handgun in his home, in your home. And he appealed all the way up to the Supreme Court. And Justice Scalia went all the way back, as he was wont to do, to be the genesis of the Second Amendment and what that meant. To a standing militia, to the right to bear arms. It's just a full history. And then he said something very interesting. He said, like most rights, the Second Amendment right is not unlimited. And when he said that, he showed a very important turning in the thoughts on gun laws. Because never before had this white elephant of Second Amendment rights been touched in that way. And here you had the most conservative justice sitting on the bench saying, wait a minute. These laws were written when weapons were very different. And now we have to look at how these tools have changed over the years and see if they still apply in the way that our founding fathers meant for them apply. And just because the Second Amendment says something and you have a right to bear arms, that is not an unlimited right. We took away the right to have a machine gun. And nobody had a riot. People, in fact, have been living just fine. They've been hunting just fine. So this is a great assignment to work on students with, to break them up into groups with. There's also a wonderful interview that Scalia gives, where he talks about if a large caliber assault weapon were to come before him, what would he decide? And and at that point, he'd always said, I don't know. It hasn't come before my court. But I think a really interesting assignment would be to have students, read not all, because the whole thing is like 111 pages, but portions of that decision, and then watch that interview. And discuss it amongst themselves, because we do have a generation that has grown up with really unprecedented gun violence, and they have very clear opinions of it. Another great decision for them to discuss would be Citizens United, because they don't necessarily understand that corporations are people. They don't think that corporations think of it as being corporations or people. And Brown v. Board of Education, I was listening to Ruby Bridges this morning talk about, what this election has meant for her. So those are just a few of the cases. So the Federal Court of Appeals, what does the Federal Court of Appeals do? So there are 12 regional district federal courts of appeal. They hear cases from 94 lower courts. These courts are always in session. This is all wrong. This is because I was going back and changing it. The federal courts of appeal are always in session. And so here's your Federal Court of Appeal map. We are here. So we're with Maine, New Hampshire, Massachusetts, and Rhode Island. Our Federal Court of Appeal is here in Boston. This is your second map for your Court of Appeals. Here's your third Court of Appeals, and that one is in Pennsylvania. This is your fourth Court of Appeals. That one is in DC. It's your 11th Court of Appeals. That one's in Florida. Your 5th Court of Appeals. That one's in Texas. Your 10th Court of Appeals. I have no clue where that one is. I have not hit that one. Your 9th Court of Appeals, that one's in Los Angeles. And your 8th Court of Appeals, and I think that one is in, I'm not sure. So as you can see, they're they're really spread out. They heavily favor the Eastern Seaboard because that's where the majority of the population is. That's where the majority of the cases come from. And then over here, you are just, kind of all over the place. And then how do you get there? So let's say you've had a federal trial and you want to appeal it. You had your trial, it didn't go well, and you'd like to appeal it. So when you appeal, there is no jury. The appellate courts review the procedures and the decisions in the trial court to make sure that the proceedings were fair and that the proper law was applied correctly. What is your right to repeal? Well, litigants have an appellate court review of the trial court's actions, and in criminal cases, the government never has a right to an appeal. And what are the grounds that you can appeal on? Well, you can appeal because the trial was conducted unfairly, that the trial judge applied the wrong law or applied the law incorrectly. The dissatisfied side can also claim that the trial court, that the law the trial court applied violates the U.S. Constitution or a state constitution. So there, and sometimes these cases do get overturned. And can anybody think of a federal trial decision that got overturned recently? Okay, so can anybody think of a federal decision that was recently overturned? It was a big case. It was in Boston.
Give us some clues, other clues.
Oh, the Boston bombing. The Boston bombing, the Zarnov case.
Yeah, wasn't he given another opportunity for
A-
sentencing?
Absolutely, he was given another
Age-related
yes.
issues.
Yes, he was given another case. He wasn't given a fair, they said he wasn't given a fair trial. And also Gary Simpson, who has been tried now, I think, twice for the death penalty in Boston. So his case has been overturned on appeal. So they do, sometimes they do get overturned. Yes, Gary Simpson is 20 years later, Gary Simpson is still, he's still kicking around. Okay, so questions, comments?
I think it's interesting how you spoke about the influence of money in the Supreme Court, and was wondering if you knew if a student found that out, is there a way for them to kind of fight against that? Who would you talk to about that? I mean, I don't know, I guess that's my question.
So there is no one for them to really talk to. I wouldn't say that. I'm always a big fan of students writing to their senators and petitioning for change. Because the court should be open to everyone. The court should not it should not be that if you have this big money type of thing, you should have an automatic advantage in the courts. So I am always a huge believer of students writing to their senators. And I just don't think you can ever put enough value on that. I know that Elizabeth Warren is really wonderful about that, and she responds immediately. Even for them dropping emails.
Good idea.
Yeah, it's because the court, that was not the intent of the court. For the court to be this, this place where you had to have a fortune in order to, have access to. And, one thing I'd like to do, because I do think it's something that students would really enjoy and would be a kind of a good breakout group, and something I'd like to do with you all now, is share that Scalia clip with you. Because I think that's kind of it's a good exercise for schools, for your students, to see a judge who was known for being really, really, really conservative. And then you see him after he has seen all the damage that these, really heavy bore assault weapons can do. And he's sitting there and he's kind of going, I don't know what I would do. You have to kind of know your students to know if that's a topic that you could broach with them. But I think that having students debate something like that, look, if that came before you, what would you do? If that case came before you, given the material that you have, and pick one or two paragraphs from his and pick one or two dissenting opinions, just see how they would discuss it and see how they would debate it. So what are your feelings on that?
I think for my students in 8th grade, it might be a challenge.
Yeah.
Just because of the age and the classes are heterogeneously grouped.
Mm-hmm.
So I think it would need a lot of scaffolding in order to make it accessible to 8th grade students.
Mm-hmm. So what about and that's what I run into with a lot of sort of the top cases, is that they are a little bit loaded socially. One of the cases I left off because I just didn't have room on the slide was the one person, one vote decision.
Mm-hmm.
And I would be happy to include that for you,
That sounds great. Thanks.
along with some additional material and also the casework that went behind that.
Mhm.
Because because of the nature of some of these decisions, some of them are really well suited for grades 9 through 12. And just because life is already so overwhelming for kids anyways today, I like to keep things a little bit more approachable for, younger students, that kind of grade 6 to 8, where they can just kind of get their feet wet.
You know what I have the kids do is identify the kind of cases the Supreme Court hears.
Mhm.
And so I actually every year update the packet. So I have it from President Obama, and then of course President Trump, and have the kids look at the cases that I think they would find interesting, and at the same time they're looking at headlines and short excerpts of these cases from the news. And then they look at those cases and try to identify what kind of cases that the Supreme Court hears. And then at the same time, how would they rule on it? And I think like one of the ones that kids found interesting a couple of years ago was the cake case.
Yes, was it the guy who owned the
cake shop.
cake shop?
Yeah, and and I have students in my class whose parents are gay, and and so forth. So the kids, I remember this one student. I showed I forget which news channel it was, but they had a very fair report, and they interviewed both sides. And the student said, wow, he said, it made him look from a different perspective.
Mhm.
He said, I understand why you're discriminating against the gay couple, but he said, but I can see this guy's perspective. So I think providing kids an opportunity to see both sides of an issue, especially when it's a social issue, it gives them the opportunity to have that discussion. And eighth graders love that. Yeah, and yeah, if you, oh yeah, thank you. I saw I'll copy your email. I could share it with you.
Yeah.
And I update it every year. So it's an identification and discussion at the same time for kids. And I always try to, if there's a video or something that they can see who the people are, that makes a big difference too.
Yeah, and so tomorrow, if any of you want to, if you're doing remote learning tomorrow, the ACA discussion, the ACA argument is scheduled for, I think, 10 o'clock. So if any of you want to have your students listen to just a little bit of it, I wouldn't recommend having them listen to all of it. That's a lot. But just listening to like a snippet of it is really interesting. And that's also so that's me coming as a civics nerd. That's me coming as a legal nerd. That's also me coming as a debate coach. Because I think it's important for kids to listen to how to debate and how to really think and ask questions on your feet really well. And that's what you see a lot of back and forth of. So we will, I will send each of you some stuff on Bush v. Gore. I'll put you guys in some rooms and send all of you some stuff on Bush v. Gore, and you can come up, you can discuss amongst yourselves and see what you want to do, and then you'll all come up with a decision, okay? Hi there. So after reading a little bit about Bush v. Gore, whatever you could find, what were some of your thoughts as it could possibly apply to the upcoming election arguments?
Well, we kind of talked about the appropriateness for eighth graders,
Mhm.
and then shared out actually some ideas with our our facilitator, had some great ideas about using a flow chart for kids and to see how cases go through the court system, as for eighth graders would be a great kind of visual for them. And we thought that was a great idea, sort of a concept mapping for students to kind of understand how a case makes it to the Supreme Court.
Okay. I'm happy to make one of those for you.
Oh, thank you. That's very kind of you. Thank you very much.
Yeah, I'm more than happy to do that for you.
Well, we got into a discussion about current President Trump and the states that lawsuits are going to be filed in and who's receiving automatic recounts. And I just think it's interesting that we can go back to, the Bush-Gore election and see how the court can and does get involved in helping some of these election decisions and how it can pertain to our kids and their futures. Whether you're talking climate change or COVID or whatever. So I think it's interesting.
Yeah, because already today, appeals have been filed, a request for recounts have been filed in Michigan, Pennsylvania, Arizona, Georgia, Nevada, and Wisconsin. And I'm trying to prepare all of you for questions that you are going to likely deal with over the next week. Georgia and Arizona are automatic recounts because it was that close. But what we have is a president who is alleging voter fraud. And he doesn't have any basis for alleging any basis for alleging voter fraud. And I think it's important that when you bring a case before a court, people would always say to me, well, what does it take to bring a court? And I would say, well, $275 and a civil action cover sheet. But that doesn't mean that the case should be filed. You need to actually have a reasonable claim, with reasonable being the most argued case in all of the justice system. Because what you never want to do is you never want to waste a court's time. Because every time that you are standing there, there are a bunch of other people with very good claims and who really do need to be in front of a judge. So when you make a claim of voter fraud or interference by poll workers, the majority of whom certainly seem to have been under constant surveillance, the burden is always on the person who is bringing the claim. And to see cases like this, and certainly claims like this, made without evidence of any substantiation, and this is a completely apolitical statement. I'm not saying anything that Chris Christie hasn't said. It is totally apolitical, and is a little bit frustrating because it's going to eat up so much of the court's time, and it is going to eat up so much transition time in a country that really values the smooth transition of political power.
Hey, Lisa, there's a line between state law here and state courts and the federal court system. And when it comes to voting, how do you move from one area, from one bucket, the state bucket, into the federal bucket? It's state law that applies here. So what does Trump have to do to get it out of a state court into the Supreme Court hands?
He would have to follow the same thing. So he would have to get an unfavorable ruling from the state court. and then appeal up to the state federal court, and then ask for an emergency opinion. He does have that right to ask for an emergency opinion from the state Supreme Court. Now, whether or not they decide to hear that, I don't know. He has already gone once to the Supreme Court and asked for an emergency opinion on Pennsylvania, and with regard to them counting ballots. And Justice Alito's opinion was they can continue to count, but anything that came in after a certain date had to be set aside. And those ballots were indeed set aside, and they were not touched. So I would expect him to avail himself of that. You know, you can always go to the Supreme Court and ask for an emergency, an emergency injunction or an emergency motion. Whether or not he gets it, I don't know. It's considered like the Hail Mary of the Supreme Court passes. Kavanaugh traditionally sides with the law, from what I've seen of what he's come out with lately. So I don't, it's a toss-up as to see what would happen. But even with, and it's more than him than just, even if he gets there, it's the distraction from day-to-day government business. Because with Bush v. Gore, and we all remember Bush won, Gore won the popular vote. Hillary Clinton won the popular vote. Joe Biden won the popular vote. So I find this a little bit mystifying. And, kind of with regard to how Supreme Courts can be moved, you can always find some, I think he can always, using the example that we saw earlier with Senator Whitehouse, I'm never sure of who he's going to find to file a brief on his behalf.
Well, I just did a quick Google search, and it looks like on the Pennsylvania case that 10 states have joined with Trump with amicus briefs.
Absolutely. Yep. Yeah, and you're gonna see those amicus briefs. And on top of that, you're going to see the Federalist Society join in. You're going to see about 10 or 15 odd little groups that are going to join in with amicus briefs. So it'll be that, and if you look at that kind of Sheldon Whitehouse thing, that chart that he held up, expect to see a lot of those same exact players turn up as amicus briefs. On this, which for me is a very sad day. But it's where we are. Unfortunately, the days of the Justice Marshall Supreme Court are gone, and this is where we are. And like I said, I'm always a big believer in having kids write to senators and just continue to be socially active. I think this is the most socially active generation of young people that we've had since the 60s. I have very high hopes for this group of young people and for what they will accomplish. And in huge part to, teachers like yourselves who put every ounce of every free time that you have into them. and are just tireless in your dedication and tireless in your dedication to educating them about civics. You know, I do a lot of advocacy work. I do a lot of work. I do a lot of volunteer work. I teach at-risk kids. I teach privately with kids now. But, you know, you guys are out there doing it every single day, and absolutely my hat is off to you all day long because it is a thankless job. And when I look at the young people you are churning out on a daily basis, it is just downright impressive. Because we all saw them. We all saw them out this weekend, and they were all celebrating, and they were all brilliantly behaved somehow. Because they had all taken part in voting in the process of democracy, and that just, you know, I was crying like a fool. And behind every one of those kids was a history teacher or a writing teacher or a social studies teacher who had really spent a lot of time instilling that love of country into those young people. So I absolutely positively I cannot thank you enough for all of the work that you do.